Okay, everybody, this is our last panel of the day. This is what's standing between you and a cocktail, so we will make it as interesting as possible. And I appreciate you guys being here to have this conversation. What we're going to do is we're going to talk about using AI tools to streamline the practice of law. One of the things that we've spent a lot of time so far in this conference talking about AI destroying us all, killing humanity, leaving us in the heap pile. And should we be afraid? Should we not be afraid? And we want to also remember that AI can be many, many things. We've talked about some of the risks and problems. AI is a tool like any other tool, and there are a lot of AI solutions that are out there that really provide minimal risk using and have a lot of benefits, maximal benefits. So we're going to talk about some of those solutions in the area of the practice of law, and just see where it goes. So if you have any questions, feel free to ask questions. Let's make this as interactive as possible to see what tools are out there and how we can enhance our own legal practice. But let me introduce the panel to you. We'll start from the audience left to right. We have Jim Durkin. Jim is a former USPTO patent examiner, and he is the managing director of product management for IP.com. Next to Jim, we have Matthew Veal, and Matthew is a European patent attorney, and he is working currently with PatSnap. He was also a patent examiner at the UK IPO. Thank you, Matt. And then last but not least, we have Francois Xavier Leduc, and he is the CEO and co-founder of DaVinci and Keeley Technology. And all these gentlemen have tools in this space, so they know the space well, they know what's available, they know what the AI can do well, they know what the AI is about ready to be doing well, and what it is that you all want or should want to be doing. So I'll ask them for their thoughts, preliminary thoughts here in a minute. What I'll just say is if you're not using AI on some capacity, then you're behind the 8 ball. You're already behind the curve. So the trick is, how do you do it and how do you use it in a responsible way, knowing what you're doing, knowing what you're using, knowing what you're putting into it and what you're getting out. And that's the conversation we hope to have here right now. So Jim, let me get your preliminary thoughts, if I can, on what it is that you would like the audience to have front of mind as we start this conversation here today.
Well, I would encourage everyone to think of AI quite broadly. We've been having a lot of talk about generative AI, but there's lots of different types of AI. There's AIs that can do things like summarization. There's AIs that can help out with things like legal analysis under 102 and 103. So I would just encourage everyone to think about the breadth of AI, and when we get into some of the specifics about what tools can accomplish today and what's on the horizon, I would think about it a little bit more than just generative AI.
Great, thanks, Jim. Next, Matt.
Yeah, I would think about AI in the entirety of the IP lifecycle, the entirety of the workflow, from R&D and innovation through to prosecution on both the attorney side and the examiner side and the patent offices, and how everything's going to flow together. There's AI tools everywhere. How do we make the most out of the AI tools that we have available now? How do we prepare for what's going to come? And then making sure that we work all the way along the cycle.
Great, thank you. And Francois?
I think AI is an amazing opportunity, and so I would like you to look at it like that. So obviously there are risks and concerns that have to be taken seriously, but it's an amazing opportunity. And what has changed with generative AI is the speed of diffusion of this technology, which exists for a long time. And it changed a lot. If you look at an interesting analysis of Goldman Sachs, it ranks the legal industry as the second one in potential to be disrupted and automated by AI. It says that something like 44% of the legal work can be automated with AI. And so a few days ago, Klarna, another company, just shared that they are about to replace 700 assistants, customer service people, with an AI, a generative AI tool. So obviously, it is here. It is diffusing in an amazing way, extremely fast across all industries. It will transform the legal industry. It will transform the IP practice. And it's an amazing opportunity for the industry to transform the way it works and it collaborate with its customer.
Great, thank you. So now, Jim, I want to come back to where you started, because I think it's could have been lost in a lot of the conversation that we've had here so far, where a lot of the panels have focused on generative AI. And generative AI is a tool, and it does allow for lawyers and law firms to engage in corporate in-house counsel to do an awful lot. But it's not the only AI that's out there, right?
Yeah, for sure. And let me just give one example of one of our AI technologies that we have at IP.com, actually one of our patented technologies. We have a technology that helps with novelty and obviousness assessment. And what it can do is it's an AI that will take a description of an invention, automatically subdivide it into the components of the invention, and then independently rank the uniqueness of all the different ideas. So you can think about it a little bit like a democratization of obviousness analysis. No KSRV teleffects required. It's just the kind of thing that someone who's even just an engineer or a inventor that hasn't had experience with too many patents, they can type in their idea and use a system like that in order to understand the obviousness. And that has nothing to do with generative AI at all. It's just a completely different class of technology. So I think that's really critical, Gene, when you're talking about these technologies, to delve into a broader variety of use cases.
Yeah. So, and Matt, what do you want to talk to us about, at least initially, and then we can dive deeper into any of these topics about use cases for AI?
Yeah, absolutely. Use case is the most important part here. So hopefully we're going to get some questions from the audience here about what's their use case and actually how can we apply AI from the tools that we do have available to their use case. So this can be things that we were talking about, patentability. It can be from freedom to operate. It can be from a more strategic area as well. I've spoken to some people here today about licensing and portfolio management, how we can apply AI to the corpus of patent data that we have and actually make sense of it and get derivable outcomes to make strategic decisions from.
Yeah. And Francois, what do you want to say to everybody about the use cases and specific with respect to the practice of law and what they can and should be doing?
Yeah, so I do agree with what you said, obviously, but still I will stick to the amazing potential of generative AI. And today I think it's already used by a lot of attorneys in helping them better understand an invention disclosure or improve an invention disclosure, getting a proper definition of a technology that they are not familiar with, or to get deeper information on this technology. And so I think there are a lot of marginal use cases which are created by ChatGPT-like technologies, which are extremely helpful in your daily work to help you get beyond the level of information you have, summarize something, reformulate, generate an email to a customer. And this is already available. This is working. This is reliable. And I think it's already amazing to be able to leverage these technologies to work.
Yeah. And so this, maybe not all of it is about, but a lot of it in the minds of a lot of attorneys and firms is about leverage, right? I mean, we've in the practice of law have lost in the United States, I'll just speak for us, for example, have lost a lot of, I guess the way to say it is lost a lot of business because companies will outsource things, things that could be done elsewhere for less money, et cetera. The AI provides an opportunity where you can do some of that work, maybe much of that work, in-house yourself, and really address the margins. Correct, Jim?
I would agree with you on that. I think that AI can help with so many different legal issues potentially. I could see very strong uses for 112 analysis, where an AI could say you give it a portion of a claim, and it could tell you, for example, where in the disclosure there's support for that limitation. I mean, there's so many potential applications, but it's really a process accelerator for an attorney, and I think a way for them to actually get business and better compete in this marketplace, as opposed to having the outsource potential. You can use AI to give a better output to your client. So I would think of it kind of that way. And 112 analysis is just one example of a use case that I think could be supported by AI very well today.
Yeah, Matt, thoughts on that?
Yeah, absolutely. Another option is, going straight back to the basics, which is patentability. We've had semantic type searching for a while, and it's not just applicable to the attorney, it's applicable to the examiner as well. I'm sure when they were able to start using semantic, they didn't have to work so hard on their Boolean search strings. What we do know is that, when you do a search, you're probably likely to find the most important art fairly quickly. And so semantic helps you do that. But if you're an R&D engineer with no real history and background in searching for patents, you can do that as well. So all along the workflow, you now have access to similar levels of information. And actually, then it gets to the nuance of, if you're an attorney, if you're an examiner, if you're a professional searcher, what's important that you're doing is making sure that that last 10% is what you're covering, and using a variety of AI-enabled tools now can really speed up that process for you, and also allow you some methodological strength in your analysis of what you've done to be robust and say, actually, yes, we've covered everything. We're going to have no nasty surprises 3.5 years down the line, but that's what we're hoping for.
And Francois, what do you see as the way that AI is enabling attorneys essentially to provide more for less, and not less of their time? It takes less of their time, so they have to charge less, and they can be more competitive. How does AI facilitate that cycle?
Yeah, if you look at the process today of drafting a patent, so 1/3 of the time is spent on the claim, 1/3 of the time is spent on the drawing, 1/3 of the time is spent on the detailed description, and the remaining on the review to make it rapid. And on the detailed description, the value added of the time of the attorney is less important than on the claim. But today, the maturity of these tools dramatically accelerates the detailed description with human-level accuracy on most of the part, ensuring the right level of claim support in the different sections, while it's not the case yet on the claim. So typically leveraging these tools, focusing on the part where they are already very good is definitely an edge to be able to have more time to put on the claims, for instance, or on the advices you would like to share with your clients to define the strategy for this innovation.
Mm-hmm. So one of the things I want to talk about is I'd like to hear from you what the most common questions are that you get from people, because I suspect you get a lot of questions about people who are interested in using it or think they might be interested in using it, and there's a lot of concerns. And maybe we can start this with and Jim, I'll start with you on this, is about the importance of vetting the tools that you're using, because I know we did a webinar some time ago where we talked about the importance of the user having confidence in the tool that they're using. So what do you tell people who have that concern?
Well, I think that's a great question, Gene. And the one thing I would say is we did send out our responsible AI white paper, I believe, to everyone. You may have a copy of it in your inbox. And if you don't, we're happy to provide a copy. But it's all about transparency, I think, is the core of it. We talked about things like the NIST framework and other guidelines for responsible AI, which are critical. But I think it's important to ask the right questions, figure out where the company is based, what they're doing with their software, how they're using your data, which we talked about many times, is critical. And being transparent. For example, one of the technologies we're working on right now is intersecting our semantic search capabilities with generative AI. And we're very transparent that we're looking at OpenAI as a provider for the generative AI portion. And I think people need to know that kind of information when you're trying to engage in a business relationship with them. If you end up working with a company that obscures things or hides the ball, that's probably the worst thing in the AI space, in my opinion.
Yeah, and there's a lot of them out there that do that, right? I mean, that, you don't know who you're working with, and we've all seen. Probably all of us in the audience have gotten these emails. Like, we can do with our AI tool, we can help you write a patent application in 5 minutes. And like, okay, well, no, you can't. And if you could, I'm not really all that interested in that output, because there's got to be a little bit more to it, and I should say even more, like some of the emails that I've gotten, what I've seen is people say, it today takes you 45 minutes to write a patent application. With our tool, you could do it in 5 minutes. It's like, well, geez, if it only took me 45 minutes to write the patent application to begin with, why in the hell would I need AI? It's, it takes a lot closer to 45 hours than 45 minutes, and that would be a real complicated application. But, what we do is complicated, and I also think, so you guys are doing, I want you to comment on this as well, and say whatever it is you want to say, and we can take the conversation whatever direction. But when people like me in the industry are getting those kinds of emails, it can't help you guys, right? And let me just ask everybody, how many of you have gotten that type of an email, Yeah,
I do as well.
Maybe this afternoon, right? Okay, so everybody's getting those emails, right? But that's what you're walking into when you're trying to sell them. They say, "Oh no, I've heard it all. Matt, what do you?
Yeah, absolutely. So the two major points, and I guess from an attorney's perspective, the first one is security. What model are you using? Whose model are you using? Where's my data going? Et cetera, et cetera. And obviously, from a PartSnap point of view, we have our own internally built model, so your data doesn't leave our systems. Which is great for you guys. So it's not really an issue there in terms of disclosure. And then from a quality perspective as well, we've talked a lot these last couple of days about data hygiene really impacting the models and giving it bias when we don't want bias in our data, and hallucinations when it's making up things that it thinks is real. When you've trained on patent data and only patent data, what you're going to get out is patent data, and so that quality is there. So you have security and quality, and that's the two foremost pillars that you need.
Yeah, and Francois, I know you're sort of the computer guy. You actually do the technology, right? Like Austin. What do you tell people when they ask questions about what do you tell them to alleviate their concerns? Is I guess.
I think the first thing, 1% in line with you. The first thing is that I do understand their concerns, and we take their risk very seriously. And I think the feedback we got from the market are extremely clear. So what is the level of security we provide? What is the level of confidentiality we guarantee? Where is our data located? And I think being extremely transparent, being extremely clear on the fact that we know the risk and we take a countermeasure to mitigate this risk, and being able to give access to the documentation that gives proof that the data is processed in that way, that it is encrypted at that step, and that it is stored and processed in these facilities is extremely critical. And I think what is very important to get in mind that it was the Far West 18 months ago when the space burst out of nowhere, and now it's not the case anymore. A lot of progresses have been done, a lot of actions have been taken by all providers, from an OpenAI to Azure and all other vendors, to assess this risk and to put measures that mitigate this risk, so that by people having to use this tool can actually trust them and be able to focus on what matters the most, basically the quality of the output, rather than the security concerns.
Mm. So what is the number, Matt, I'll ask you to go first on this. What is the number one question that you get from people who are interested in potentially using your AI?
is it secure?
Yeah.
That's it.
Same.
Yeah. And Jim, is that the number one question you get, or?
I would say either that or confidentiality of the queries.
Yeah.
That one comes up a lot too. People being concerned about obviously their proprietary ideas not being used for training purposes, things like that.
Mm-hmm. Yeah. So, and Matt, I think I heard you say that your system has been trained on patent data, right? Yeah. I mean, that's one of the things I wonder is like, and not to beat a dead horse because I've said it so many times, but I can't imagine like for what we're doing, using a model that's been trained on Reddit. You know, I mean, that would just not seem to be best practices. And because it really matters. I mean, the quality of the data really, really matters.
Yeah, absolutely. I mean, we've said it over and over again, garbage in, garbage out. So, you know, the data quality is foremost importance.
Mm-hmm.
Do you categorize the patent data that you feed in any way as good, bad? Because I think we all know, we've all seen a patent application or two that we think is good, not good.
So the question is, do you characterize or grade the patent data that you are putting in training so that the system, the computer, learns what is good and what is maybe not as high quality?
Yeah, I think that's a subjective question. I think having worked as an attorney, I'd never comment on the quality of someone else's work in case they were to comment on mine as well. So I'll leave that one to the side. But you do have objective data such as dates and translations and standardized assignees and things like that are important and that have been worked on for the last 17 years or so that we've been around and then fed into the LLM, so that actually gives even better data again than just taking what's available publicly. You have the additional bits that we've worked on before, which I'm sure you already know about, but we can go into as well.
Yeah. Any thoughts on
yes,
that first one?
Perhaps I think AI is not monolithic technology. So typically in our system at DaVinci, we have layers of models which are doing things in parallel or sequentially. We have 20 different models for different purposes. And some of these models are generative, and for some of this technology we rely on third parties like OpenAI. And some models have different other purposes, typically assessing where the claims are supported in the draft generated. These technologies are different, and I think your questions relate to the quality of the training data. Depending on the purpose of the model you are developing, it might be relevant to rely on Reddit data. If you want to assess the quality of the claim supported into the draft, I guess it's not the right strategy.
Mm-hmm. Jim?
I was smiling a little bit because I was thinking our content team would tell you that the patent data is pretty messy. But the reality is that as far as sources of training for an AI system, we also use the patent data as the basis of training our semantic engine. It's overall, I would say it's fairly well structured. There's a lot of useful fields you can get from it. There's obviously a ton of description in patents. I mean, it has to meet the legal requirements for written description and enablement. So you really do get a wealth of data for training an AI system by looking at patents, and it's a good approach. Even if you also do things like search non-patent literature, which our system does, you can still get a lot from training on the patent data.
So have we gotten to the point yet where like a large enough user, and some small companies couldn't do this, they can come in and say to you, hey, I want you to train your model using my patents or the patents that I think are the best that I have, or maybe a subset of patents that I particularly like because I think they're well written. Take, for example, I've said this many times before, I tend to think Apple patents are extremely well written, right? Not shocking, I guess, right? Given what they're inventing and so forth. Have we gotten to that point or not? And maybe if not, is it because that you need so much data to train these yet that you can't say, just learn off of Apple patents?
I can take it if you want.
Sure, go ahead.
So same for models. For generative models, you can think about these models as layers. So you can have a base model, which is a very large model doing the main processing, and then you can have a layer of specialization on gene queen, because you have enough data, you've published enough data, and the model has been specialized on your data. So typically at DaVinci, we offer very large firms to do that work for them. So we specialize the baseline model with the data of some of their biggest customers, for which it's important enough to do that work. Because if we don't do that, imagine that in 5 years from now, every patent will be drafting will be supported by the same models. All patents will be similar. Mm-hmm. And so the future is definitely in a specialization, personalization of these models, and this has been shared by OpenAI as well. I think it's
okay. And if anybody has any questions, just raise your hand. The panel will see you, and we can.
No, yeah,
go ahead.
There's a question.
And I think you said earlier that you rank the various elements of whatever the invention is to determine, I don't know what term you use, novelty, I guess, maybe,
Yeah.
And maybe how, I don't know if it gets to the obviousness or not. But, so did I characterize that correctly?
Yes, that's correct. That's one of our patented technologies. I'm quite familiar with it. I'm actually one of the co-inventors on that. It's a method of letting us understand the novelty. It can also do obviousness by segmenting the idea first with the artificial intelligence into the components and then giving individual novelty scores for the components. But yes, that is one of our technologies that we have available at IP.com.
So then the question is, how do you account for the fact, for instance, in biotech, sometimes, I mean, I know of one patent application where there's something like, there's got to be 25 or 30 patents issued off of it, and there's probably another 25 pending applications right now. Wouldn't that factor make it look like it was less, I mean, make it more obvious than, say, a mechanical case where maybe there's only 1 or 2 patents?
It definitely could, but to be clear, the way that particular AI works that I was referencing is not going to look at those type of factors. It's going to be more concerned with how close the description of the idea that you put in is to the prior art, and it's a way of measuring that. It doesn't look at things like citation, for example, but as a practical example, I think those would be things you would consider more broadly when you're looking at things like obviousness.
One more, if I might. I don't know that they still do it, but back many years ago, DuPont used to be notorious for taking something that was known and describing it with new terms and getting it allowed. How does that factor into your AI?
Well, that's a challenging thing. I mean, there's a whole field about issues about detecting things like semantic drift or like changes in terminology, how words can have different meanings across time, or words can potentially be deliberately obfuscated. One of our other AI technologies I didn't talk about is actually a way of automatically detecting jargon in an invention description. So that's one of the ways we would deal with that problem with our system, is we would actually flag, hey, this is an unrecognized word to the AI, and we would prompt the user, if it was an engineer, to say, hey, you're putting in jargon or industry terms that the AI does not understand. Please rewrite it. So we do have some technologies to detect when that has occurred, which I think relates to your question. Very good question.
Yeah, I wondered how long it would take for us to get quickly to the subject of subjectiveness rather than objectiveness, which you might be able to find a little bit easier with understanding novelty. When it comes to inventiveness, is if you put in your draft, is it going to say this is the inventive part? Is that a test that AI can do when actually there's years of case law, there's examiners sitting at the patent offices going, I hope I've still got a job when AI really comes for it. And I think that's a good question to ask, and it's how we actually deal with it and how we deal what do we do with that? So from patent staff's point of view, we have what we call patent DNA. You'll know that patents and applications themselves have developed over the years, in how they're structured and how that changes in line with case law and technology and cultural norms as well. So the AI models that you use and the things that you're training with has to take account of those cultural drifts, those semantic drifts, those changes in terminology, what we call patentees, and bring that all together. And it's good, but I like to think there's still a job for everyone in the room for now. So when it comes to subjectiveness and understanding if something actually is truly inventive, that's the bit where we have our say still.
There's that concept of for now again.
There's another question.
We led to the first panel of the conference off with Jason saying AI isn't going to kill you all tomorrow, which implies that it could the day after tomorrow and eventually will. And at what we're still talking. These are tools that facilitate practitioners to do what practitioners do better and more efficiently. Right? These are not tools that are going to replace anybody that's not the intention. Currently, at least, right? I mean, and I say that like that because I personally don't think it's going to replace practitioners. I think, and you read this all the time, and maybe you guys could comment on this if you think. It's funny how everybody thinks that AI is gonna hurt the lawyers the most. And I laugh the hardest when I hear a doctor say that, or a medical professional. It's like, no, AI is really most at risk of hurting the doctors in the medical profession, because when you feel really bad, you go to the doctor. What do? They take all kinds of readings, your blood pressure, your temperature, and all of that sort of thing. And then they ask you, well, what symptoms do you have? What do you feel? And it's a matrix, okay? If this, then likely that. If not that, then likely that. If not this, well, then I can't really help you, That's not what we do. I mean, there's a lot of persuasion that goes on in here, and there's a lot of accentuating the positive and describing things that matter, and you describe them in unique ways, and it's not that kind of matching. So this is really, for the foreseeable future, in my mind, a tool to facilitate the high-level practice of law. Would you all agree with that?
Yeah, I'll
Go ahead.
jump in.
Go
I'll
ahead,
go
Matt.
first, shall
Go
I?
on.
Yeah, so I think you're quite right, not to jump to the fence of doctors or anything else, but realistically, we're in the business of communication. Obviously, we have to do a lot of learning and get expertise to be able to then communicate the most important things. But what we're doing is trying to, with AI and the tools that we have for practitioners, as I said, from the entirety of the workflow, from your R&D engineer inventing something all the way to your lawyer prosecuting the patent attorney, is shrinking that communication gap. So if you can upskill the R&D engineer to understand a lot more about patents by making it easier for them to consume, and then also making it easier for the attorney to explain that to them, then that communication gap has shrunk. So what you're really doing is upskilling your client, or whoever it might be, internally, externally, to be able to a level that they can make a decision on something they don't know about. That's why they've come to ask you. So you need to make things simpler for them, or upskill them in their knowledge to be able to make that decision. And that's what we're trying to do with AI at the moment, is shrink that knowledge gap.
I think that's a good way of kind of just describing it.
There is a question.
Yeah, we have a question. Go ahead.
So I want to go back a step. So I'm not a patent attorney, but I am an educator, so I look at validity and reliability a lot. And so I'm curious as to your systems evaluate, they grade in different ways the invention, they advise based on that information, humans then make decisions about it. Does the next step get fed into the process so that you're comparing the projected value against PTO decision making, and so you're actually getting validity that we said this was going to be found invalid, it's obvious, so did the PTO, this one we were wrong on, so that there's a feedback loop that improves the output? Or is this a separate process from the actual reality?
Well, I'm not sure I'd frame it that way. I wouldn't say it's a separate process from the actual reality. What you're talking about in terms of a feedback system, though, is challenging if you think about the time delays that would occur if you were to try to do that type of analysis, because it takes several years for the patents to issue and they undergo prosecution for a long time. It wouldn't be something that would be really easy, for example, to validate the functionality of a new AI system to do that kind of comparative analysis. I mean, you certainly can if you kind of do a retroactive analysis, and that's one way to do it. But it's tricky because there's a lot of delays in the process that would make it difficult to kind of have an immediate feedback loop.
I mean, just my analogy, right?
Yeah.
So we design our first-year law school courses, and we use bar data to tell us whether or not we're effective as teachers, even though it takes 3 or 4 years for the students to hit the bar. So we've all gone through that process, right? So, through the course of law school. So even if ex ante you can't do that day one, right, these systems are going to be around for a while. So again, I come back to validity and reliability says that these talk to the actual decision makers. It's well beyond just the patent legal services. Right, so TurboTax works because the IRS validates those returns. Probate documents, we get feedback. Insurance documents, quite frankly, easily automated because they're standardized forms. So this is happening across legal practices, but I guess it's a comment, unless it's grounded in decision processes that have that feedback loop, why would I want to have decisions made based on it?
So I think I can answer that question, because this is something I think that one of the reasons why I also think that lawyers don't have to worry about AI in probably our lifetime. And I'm talking about patent attorneys, patent attorneys particularly right now, right? Is because if you look at what the Federal Circuit is doing and deciding in these cases, they don't stay in any one spot for more than a couple years, and then they want more, and then they go to then you give them more, and then they're like, okay, well that wasn't enough either, and then you more and more and more and more. And I jokingly said one time that I went back and I looked at it, I said, over the last 20 years, you wouldn't have given, with respect to software, which is the area I know the most, you would not have given a client the same advice for more than 2.5 years. That there had been, every 2.5 years, a major event that changed everything. Not always patent eligibility, KSR included, not always a law or statute. It was the second pair of eyes at the patent office, that just killed all kinds of patents. But there was always, and I went back and I looked, and I was exactly right. It was about 30 months was the longest window, and as long as that happens, we're going to have a job, and it makes it. So I get, so maybe to take John's question, the next thing, how do you guys make sure that, or maybe I think what you're doing is you're trying to make sure that the output is best practices, right? Realizing that some examiners are going to allow everything, because there are that do, and there's some examiners that are going to allow nothing, and they do that, and some of them are in the same art unit, right? And we live in a space where there is, unfortunately, for better or for worse, no uniformity of decision making. And that can be exciting, it can be scary, but I think it's true. So how do you solve for that? Is it just to make sure that you get the best information about the innovations and do the best that you can, and then make sure that there is that human involved, that Europe, Matt, you could talk this first because you're from Europe, but the Europeans always seem to want to have a human still involved.
Absolutely. Maybe I can conceptualize this a little bit in a kind of hierarchy. So data, any patent data or even decision data. So when we get that data, to get it to information, you use an analytics platform to triangulate it. What we then do with an LLM model or any AI model is take that information and turn it into knowledge. But then that's not where it ends. You have to go to the next step, which is wisdom. And that's where the person comes in. So, but along those points, you will get, whether it's a PTAB decision, you feed it back into the data, that then makes new information and feeds it all the way back up. But until we have something that sits in between knowledge and wisdom, that's going to be the person. But everything else is helped by data and feedback through there. Does that seem like a reasonable way of describing it? Are you going to put it in your course?
To me, I think that makes sense. But Jim, Francois, do you have any thoughts on Francois?
Perhaps a way to bring an input to this question. We developed a framework to assess the performance of the tool. So generative tools are by definition subjective, producing subjective outputs. And so being able as an attorney, as a law firm, to rely on the right models means being able to assess the quality of these models. And so we developed a performance framework that combines that defines the performance in terms of speed, so basically productivity gains, and quality. And the way we gather data on these two inputs is by bringing in humans, so basically attorneys, and we run surveys with samples of patents that we know that have been drafted manually and that we draft with DaVinci. And we measure on these two dimensions, so the time saving and the quality of the output, thanks to the contribution of the attorneys participating to the survey. And thanks to that, we have a framework that helps to make this assessment more objective and helps the development team improve the quality of what is generated by the model.
I think that there's so much subjectivity, especially around some of the areas we're talking about, like obviousness analysis, that there's always going to be a role for the attorney, like you're saying, Gene. I only see it being accelerated by the adoption of AI. It's one of those things where a computer can tell you certain things. Like I gave an example of our obviousness technology where the computer can tell you the difference between your query and the prior art in terms of how different it is semantically. But the computer is not going to tell you that this examiner is going to choose to do a particular KSR combination in this case and give you a rejection ultimately. You can look at statistics, of course, for individual examiners, as many do, and get an idea about whether or not you should go right to appeal, which I'm sure practitioners do every single day. But there's so much subjectivity, in especially around obviousness, kind of a mixed question of law and fact, and really something that I think will keep us all employed for a very long time.
Yeah, and so I, but this is an interesting line of inquiry, right? And as I'm sitting here thinking, a lot of the areas where there's these feedback loops, like for example, TurboTax is, like if I take a deduction and you take the deduction, TurboTax is going to treat them the same, and the audits will treat them the same. You're either allowed to do that or you're not allowed to do that. But when you're dealing with examiners, and then when you're dealing with federal circuit judges, you do the same thing that I did, and you might get thumbs up and I might get thumbs down. I mean, so this is a really strange area of law where, with the federal circuit, you can't predict with 100% certainty the outcome until you see the three judges that walk in the room. And then once you see those three judges, whether you won or you lost. You can probably just say, yep, we're good. Now that we know who you are, we don't need the oral argument. We'll talk to you later. And that's one of the real frustrating things about the practice that we live in. And also, but I think underscores the need to have some mechanism in place to help us as attorneys do more with less. And the less is clients continue to want to pay 1980 prices, and it's 2024, and the federal circuit wants us to do more. And well, how much more? Well, I'll tell you next time, when next time wasn't enough too. And it's frustrating. So I think that's why a lot of attorneys are looking for these tools, right? I mean, what is the driving force for people who come to you?
I think you've captured it perfectly there, and I think we've all talked about it the last couple of days is that a lot of people started as patent attorneys, but that's not how they describe their job role now. And that's just because we have to evolve with the times. And one way of doing that is to have access to more data and more strategic influence over your client, whoever that might be, internally or externally. So you've talked before about landscaping and white space analysis. And we mentioned a black swan event, and actually it's a grey or white swan. Well, actually, same with white space analysis, it's more grey space analysis. And that's where you then apply your years of wisdom into making those decisions. But actually having those tools that make all that data available to you, such as an analytics platform with AI built in, would allow you to make more offerings to your client. As we go back to before, we used to look at ways to outsource searching to places that could do it more cost effectively. You can bring that in-house with AI type searching, as long as you suitably caveat how good the quality is going to be. It's going to be very good, but always make sure you disclaim that in case someone finds something 4 years down the line, we didn't know about it, we did the best we could do.
Yeah.
Those things are always going to be there.
And they're always going to be there, right? So I had an occasion for a project I was working on, this is now many years ago, looking at Rovi, the old TV Guide portfolio that then Rovi bought. And you could see, okay, well, this was the way that they wrote the application during this period. And I thought, oh, that's pretty well good. And then a shift, well, they started writing them in more detail and including more stuff. Well, what happened? Well, there was one of those pivot moments. And they kept chasing it. And the only thing that was consistent throughout was every time one of their patents got challenged is it lost? And what they were doing at the end was so dramatically different than what they were doing at the beginning, because the standards had changed, but it still wasn't enough. And that's the frustrating thing. How do we do more for this change? Because in the patent world, patents, clearly, they're not property. Because if it was property, you wouldn't have retrospective application of the law. And that's unfortunately what we have to deal with. So we need to find tools, I think, in order to help us chase our own tail. Or to chase the Federal Circuit tail, really, is what we're doing. But let me ask you, is there any other questions anybody have? If you have, just raise your hand, and the panel will see you. But while you might be thinking of some other questions, let me ask you this. Something I've asked some of the panel and some of the people during the breaks and so forth, and over drinks last night. What is it that AI does really well today for enhancing legal practice? What is it that it's going to do really well tomorrow, and what should we be looking for in the future? Jim?
Yeah, I would say that I think generative AI actually works quite well today for things like structured ideation, for trying to brainstorm to problem solve. I think there's huge promise and potential in generative AI for a variety of applications. I think that some of the technologies I referenced earlier, like our novelty and obviousness scoring, work remarkably well for the use cases that they're designed around. Things like summarization using artificial intelligence, we have a technology for that that can be very effective. The near-term trends, I think we may start seeing a move for some of these generative AI models to be hosted locally. I know it's something we mentioned in the prep call. There's been some research papers from Apple that are hinting at ways of doing that type of analysis better on a phone. So I think that there may be a day coming very soon where it's not the generative AI in the cloud, it's the generative AI in your pocket.
Mm-hmm. Well, that certainly addresses a lot of the confidentiality concerns and for proprietary information and that sort of thing as well. Matt, what do you think that AI does really well today that attorneys, if you're not using it, you should be?
Yeah, absolutely. I think I'll refer back to my previous comment, which is it narrows the communication gap. So anything that's objective between an attorney, an examiner, or an attorney and their client or the engineer, then it narrows that communication gap by making things that might be complicated more simple. What we're going to look for in the future, in the coming months, and maybe in a year's time, is that it moves towards a more strategic level. For example, as you were talking about earlier, can you get a nudge towards what you should be looking at from a strategy level? So if you were to take a portfolio of patents and work out where it's licensed now, where is it potentially going to be able to be licensed to later by looking at someone else's portfolio and seeing what they're working on, looking at the intersects from the data and upping it from data intersects to information and into knowledge, and then making those decisions. So that's where we're going to go.
Mm-hmm. And Francois, what do you, like if somebody or asks you, what do I need to be using it for today? Or why do I need to use it for today? You say because it does what really well?
So if you take the patent process, so basically claims, drawings, description and review, it does very well the two last parts. So it's extremely good at generating the detailed description. It's a small section, so introduction, background, summary, description of the drawings, on which it is really amazing. And the review, which is more objective and relying on other technologies. And it is still limited on the claims because it's not able to generate accurate claims based on a description. This might come in the future. I think the big change in the 12 coming months is personalization. So I agree, one trend will be localization. So being able to run these models, these big models on more private instances. And the other one is personalize the AI, being able to specialize the AI based on the user profile, on the data which is specific to a customer or to a firm, to be able to increase the quality of the generation and to be more contextual to the very specific patent you are drafting.
Okay. Well, we're coming up to the 6 o'clock hour. So maybe what we should do is we should go around the table here and get your final thoughts. What is it that you want people to understand or remember or know about using AI as a part of their daily legal practice? Jim?
I would just encourage everyone to keep in mind how fast this technology is progressing, particularly in the generative AI space, and just to know that these technologies are here today, they're workable. We have them being used by many large corporate clients. The benefits of AI are here today, and if you're not adopting them in the near future, it's going to be difficult to catch up.
Yeah, great. Thanks, Jim. Matt?
Yeah, absolutely. We could probably go for another hour, and I think it's been important to answer the questions from the audience, because those questions are things that we have answers for with AI tools now. As I said, and probably what I'll end with, is that your clients are using AI tools, the examination officers, the patent officers will be using AI tools, other people that you work with are already using AI tools, so you need to be on board and ahead of the curve.
Great. Thanks, Matt. Francois?
I think AI and human capabilities are extremely complementary. And so we have to have that very clearly in mind and leverage these technologies and our capabilities in a very synergic way. AI will not replace attorneys, that's obvious, but it might, attorneys using AI tools, familiar with AI technologies and such tools, might replace the one which are reluctant to use these tools. And so start using them, get accustomed with this technology, learn how to use them, and everything will be fine. Huh?
Yeah. So my final thought is I think people, you need to be using AI. You need to be investing in it. You need to be, because it does certain things very well right now today, and it can streamline your practice. It does other things. It'll do better in the future, but the fact that it's not a perfect solution right now for every last thing you could possibly want it to do doesn't mean that you shouldn't be using it for what it already does really, really well. And the other thing is, if you wait until it does everything really, really well with software, when is that ever going to happen, right? in our collective experience, there's always updates, there's always next version, there's always, so if you're waiting and waiting and waiting, all you're doing is you're letting the world pass you by, and more importantly, your competitors pass you by. The other thing is I think this offers patent attorneys, particularly like in the United States, who may have lost a lot of business over the last 30 plus years to drafting overseas and over whether it be drafting or whether it be prosecuting, it gives you a meaningful way that you can bring that back here. And I think U.S. patent attorneys provide great quality, and why not take advantage of some of the tools that allow you to do that rather than needing to leverage somebody who literally is on the other side of the planet, who may be in a country that doesn't particularly care about intellectual property rights, that they may or may not even understand the need to keep things secret or confidential, when you can do this in your own firm, with yourself or with your own trained people. I think it's a tool that we all have to embrace. Of course, there are questions that need to be answered. Where's the data? Where was it trained on? And there's solutions to that. And if anybody in this space is trying to sell you a product and they can't answer those questions, just hang up the phone or delete the email, right? Because they're one of the pretenders. And I always tell people in this space, you don't want to do business with the pretender. You want to do with somebody who's honest and open and tells you what's going on, because there's just too much at risk if you get involved with the wrong company doing something. Just like in Hill Street Blues, those of you who are a certain age, you'll remember, hey, be safe out there today, and that's, I think, the way to proceed with AI. So thank you, guys. Thank you very much.
Thank you.